I'm back, and I gotta say, welcome to Freight Expectations. This is a special thing we're changing up, Freight Expectations. Normally, Matt and I pre-record it, but we are so electric live, and we thought we had rolled it into FreightWaves today. Matt, how are you?
I'm doing great now that I had the clip of Premier Trailer Leasing. You know I love trailers. You know I love maintenance, Craig. So I'm excited, man. Live and in person, or kind of in person. We're getting closer. How are you?
Yeah, I mean, you are the trailer whisperer. So you and Chris Hines are the only two people that I know that don't work at Wabash or a trailer company that love trailers. Matt.
Everyone loves trailers. Everyone loves trailers.
Well, you got to have them. You know, it is important. I mean, you think about the trailers, they're more important than the truck in some ways, right?
Absolutely. You can repower an asset. The trailer is what all the freight is in. Like, you want to know, where is my box? And that's the beautiful thing about connected trailers, my friend.
So, Matt, what is in the world of all of the stuff that's happening, legal? We were a couple of weeks past the Supreme Court decision, the Montgomery decision. What's sort of the fallout of the world right now?
I mean, it's still a lot of uncertainty, Craig. So everyone is asking the question, what is a safe motor carrier? They're asking, what is a reasonable vetting process? And the reality is, nobody knows. You're not going to know until you have litigation and case law. And so this is going to continue to percolate for the next few years. We'll likely see more cases go before the Supreme Court. But as it stands right now, there's a lot of uncertainty. And uncertainty in the midst of a freight economy that is booming, I think people are still getting excited about everything.
Yeah, our prior guest, Mark Scudder, who's also an attorney, talked about this. And he's more on the security side of the world where transactions are being done, M&A transactions. He said a lot of the logistics deals are certainly, there's been, I wouldn't call it loss of momentum is maybe not the right term, but certainly a lot more question in terms of sellers and buyers of really what this all means. I guess the buyers are the ones that are impacted. What are you seeing?
Yeah, there was so much pent-up demand coming into 2026. So a lot of deals that were going to happen in 25, those got sidelined. And now we're looking at 2026. And we say, well, what deals are going to happen? Well, for a lot of freight brokers, 3PLs, and managed transportation companies, the game is now changed. The fundamentals of when you might be held accountable for a driver who is unsafe and has an accident. This is what we're going to have to understand. So a lot of people that were really looking to get deals done, now there's a little bit of a slow play. What do we think the future holds? And we're not going to know for many, many weeks. Ultimately, I think the deals will still continue to happen. People either want to take some chips off the table, they want to recapitalize the business, and there's a big appetite because even though here in Chicago it's pouring rain, freight never stops. No matter what happens. So we're going to continue to see people need the stuff inside those beautiful trailers.
Matt, it's beautiful weather down here. I was in New York yesterday. It was beautiful up there. I'm sorry that it's been raining in Chicago, but this is the busiest time of the year. Speaking of weather, June just drives so much freight demand. We're seeing incredible tightness and capacity. I think the question that is still on a lot of folks' minds is how much have we seen the SCOTUS decision really impact the freight market? Earlier I believe it was last weekend, there was a report that C.H. Robinson is starting to cull its carrier base, is starting to be far more selective of which carriers it's going to do business with. How pervasive do you think that is?
I mean, this is the big question. Like, what do you have to do to have a reasonable vetting process? And for someone like CH, one of the biggest brokers that's ever existed, you're going to have to really look closely at what you allow in your network. So conditional-based motor carriers with safety ratings that are, again, conditional, probably gone. I mean, they're not going to have the risk to take that type of liability on. And one of the things I think is going to be really interesting, Craig, that we're going to find out, a lot of large 3PLs and even shippers that work directly with motor carriers, they looked at their carrier vetting process as confidential, proprietary information that they were going to keep very close to their chest. But now that's going to be litigated every single time an accident occurs. So we're going to learn very quickly what every single major broker and major shipper does when it comes to how they onboard capacity, how they monitor capacity. And you're going to, I suspect, see a lot more culling as we wait for the federal government to kind of get MODIS fully implemented, find out ways to get rid of bad motor carriers. But as of right now, it's keep things careful, and you're going to see rates likely go up as a result of that.
Yeah, I mean, there is a question. I mean, I've said it. I don't believe that the SCOTUS is the driving factor here in the rate market. There are folks on X that have disagreed with that, and maybe it is. I mean, when you have a company of the scale of C.H. Robinson cutting back on the capacity or cutting back on whom its providers are, that certainly it tells you a lot about the fact that it probably is having an impact. Maybe not the only reason for sure. I mean, freight demand is higher. We saw the employment report today was much stronger. The economy appears to be I don't know if you've paid attention to the show this week, but I think consistently across the board, we had the second largest LTL player with Estes on their largest private transportation company in the United States. We had their CEO on, and he talked about just frankly how surprised they were on consumer activity. We then had Shelley Simpson with JB Hunt, CEO JB Hunt, the largest surface freight transportation company in the United States. We had STG, a very large intermodal player in the United States. We had ShipStation CEO, $200 billion of transactions. And consistently, again, all of those parties consistently talked about the fact that freight is strong. Aaron Graff mentioned as well. So it just strikes me that the economy is holding up better. We're seeing it in employment data. We saw it in ISM. We saw it in LMI. The railroad data has been really robust and quite strong. And I think it's interesting because that demand side is certainly having an impact. We know that, particularly in sort of flatbed and certain modes of traffic. The supply side is also getting whacked at the same time through this compliance crackdown. And now you have SCOTUS. And I still don't think SCOTUS is the primary driver, primary catalyst. But, if we continue to see more and more brokers start to cull their carrier base, it's got to have a huge impact.
100%. I mean, what we're seeing is this renaissance or a great freight awakening of people saying, okay, what is actually happening in the supply chain? And we see the CBS reports that come out. We see that about Super Ego and other brokers and motor carriers that are putting people on the road that aren't necessarily the safest. We saw the FMCSA. You and I interviewed Derek Bars together, and phenomenal work he's done with the FMCSA. But what they've really focused on is driver qualification. So English language proficiency, non-domiciled CDL, entry-level driver training registry, all of these initial kind of places. But we still realize, even with after International Road Check, there's a lot of work to be done. And now that there's a new kind of game in town, meaning anytime there's an accident with a truck that's involved and there's a broker involved, the plaintiff will sue the broker. They have no choice. They have to sue the broker. Now, maybe the vetting process that they use is going to be consistent with a reasonable standard of care. Again, we don't know that, but we're going to see a lot more of this moving in that direction. The thing that troubles me, and we've talked about this on the show before, what about the American consumer? What are we looking at with credit card debt or auto loan delinquencies or mortgage missed payments? These are really important things that'll drive the ultimate, the consumer demand for buying the stuff that we have. And that should concern people, I think, as we see gas prices likely continue to climb in the months ahead. Hopefully we have a resolution to the excursion at some point. But what we know for sure is that motor carriers and brokers know the federal government is trying to make the road safer, and they're putting more things in place to try to drive that. You and I both agree, and I think we can assume the FMCSA is probably on the same page. They need vastly more resources. That there's no doubt in my mind that if we want to have safer roads, you want to get home in the same condition that you left, which we all want, you need the regulator with a lot more teeth and a lot more resources. And that is still TBD in the days and weeks to come.
Now, Matt, is the requirement, if you're an attorney, and again, I've never gone to law school, and I think I got a D in law school because I hardly ever showed up. In fact, in college, I had a problem of forgetting that I had to go to class or not going to class. I remember I got a D in legal because I didn't. And the problem is, this because you're an attorney, is you can't really fake it in legal classes. A lot of things in English, you can write these great things. History kind of repeats itself. But man, if you try to fake it in your legal classes, you're going to flunk out. And that was the story of me, as I really didn't do any of the homework. But I got to ask, the idea that you have a fiduciary obligation to your client, or you have an obligation, I imagine it's a fiduciary obligation.
Yeah, it is a fiduciary, absolutely.
To sue the broker is all, that actually is something that I think a lot of, frankly, brokers who believe they're going to be somehow exempt from this just don't understand.
Yeah, I mean, that's a really good point. So when you're a lawyer, you absolutely are a fiduciary for your client. And with the law, you have to bring any claim you have during the kind of the nexus of events. So if you find out, okay, there's a motor carrier that was in an accident. Whether the motor carrier was at fault or not isn't really relevant at this stage, but we're going to make the assumption that there's some culpability. You're going to say, well, who else was involved? And again, we've talked about the insurance numbers for motor carriers, the federal minimum being $750,000. So if you're looking at a potential claim, you're going to look at who is involved. And if the broker is involved, maybe even the shipper is involved, if there's a leasing company in play, if there's a manufacturer that might have some culpability, you're going to bring those claims right away. Now, if you don't have good facts around those things, you may just issue discovery and find out all of these things and then amend your complaint to bring these claims in. And so a lot of brokers know this, obviously. You have a requirement legally to have a $75,000 surety bond. Now, that has nothing to do with liability in catastrophic accidents. It's about cargo and paying carriers and all this. But when you look at what insurance does for you is it helps defend you. It pays for the cost of a lawyer. And when you're in litigation, you might have $20,000 a month in legal expenses completely absent of any finding of liability. So even though our federal government does not require brokers to carry third party or contingent auto kind of liability insurance, you better believe they're going to start having this. Now, the big brokers already have it. They're going to see their renewals be a little bit more frustrating, a little bit more expensive. But for brokers who have not thought about contingent liability insurance, they're going to have that conversation, and they're going to have it very soon. Otherwise, you'll have a bunch of chameleon carriers and a bunch of chameleon brokers who get knocked out by litigation, pop up a few months later, and get right back to it.
Yeah, chameleon brokers are definitely where this is headed. But I got to ask from bankruptcy court, because that's where these would end up somehow in bankruptcy. That is hard to it's quite easy, as I understand it, particularly small businesses, to pierce the corporate veil. The idea that I can prove that you have intermingled accounts, or I can prove that you've intermingled your personal life. I know a lot of brokers. These guys are really smart about slinging freight. Some of them are incredibly great business people. Some of them are by the book, but some of them are not. And those are the people that I think are going to get screwed when it comes to piercing the corporate veil, because they're probably not thinking about this. They're probably not thinking about the fact that I need to have a very separate set of books. I need to have perhaps a formal board meeting. I need to have board minutes. I need to have bank accounts that are separate, legal agreements. I can't just intermingle my personal life and personal funds with the business. What is the advice that you would give somebody that is a broker to ensure they have some protection?
Yeah, the first thing I would say is don't take legal advice from a television show. If you think you need a lawyer, you probably do. It's not me.
But it's free, Matt, and that's the point. This is a give.
Yeah, that's right.
We're not giving legal advice here. You
That's
can't.
right.
I love your statement about it. But it's
advice
free.
I would give,
People love free, non-billable hours.
That's right. That's right. We're all on a contingent side anyway. What I'll tell you is, just like your sponsor loves talking about preventative maintenance for your truck and trailer. Yeah, you need to change the oil on that truck at a certain duration of time or certain duration of miles or engine hours. Like, you have a cadence for when you get your equipment inspected and maintained. If you're in the business of moving freight, or any business, this applies to anybody in any type of industry, you need preventative maintenance on your company. What is happening with the law? What is happening with regulations? You want to talk with your insurance company as often, maybe once a quarter, maybe once every 6 months, to say, am I doing enough? Am I doing it right at this moment? And then you want to work with your outside counsel. Say, hey, here are the contracts I use. Here's how this stuff operates. Because to your point about piercing the corporate veil, it is difficult to pierce the corporate veil, but it is easy to do if you, to your point, commingle funds or underinsure a business. Like, that's a big one. If you underinsure your company and you're found liable, they'll go after you personally because they would argue you should have known better. So if you're open to preventatively maintaining your equipment, and everybody should be, then you should also be open to preventatively maintaining your business, having your contracts reviewed, having your policies reviewed, and making sure that you're doing everything as reasonable as you can, because when you don't do what's expected of you, that's when you have the liability. So if you have a really good process document, but no one follows the process, understand that my brother and my sisters and brothers-in-law are going to come knock on your door, and they're going to start reaching into your pocket.
And just like Mark Scudder was on, again, he's a transaction attorney, and I asked him advice that he would give a founder, an entrepreneur wanting to sell their business. And he said, look, get ready. Start today. Start early in the process. Make sure that you're ready. well before you start talking to bankers, well before you start talking to attorneys, is get your business ready, because if you find something out in diligence that maybe the business isn't as clean or isn't as performing to the degree that the buyer would expect or want it to be, it's gonna ding you in price. It's also probably, you have the risk of deals falling apart. I've walked away from deals myself and have been on the other side where we've had deals. Years ago, I ran a payments business, and we had a big buyer that came in, private equity firm came in, and I was young and I didn't understand and appreciate what that process looked like, but they came in, did diligence. They walked away the next day. They said, we're just not comfortable with these things. And they were not, to me, as a CEO, someone in the business, I didn't think they were that consequential, but there was just enough of them had piled up to where they had doubt. And I think you would probably agree that it's the same thing with plaintiffs' attorneys. They don't have to find one thing, but a series of things. It's just like in a murder trial. My wife and I watch a lot of these murder shows. Women love those things, by the way. Like the Lifetime shows.
That's right. Give me the
it's
blood
like
and
the
guts.
opposite of Hallmark. Hallmark is like everyone's lovey, and it's the typical, dude from the city. The girl's like the country girl, comes in, and if they fall in love. Hallmark always happy ending. Lifetime is always bad endings. Women love the extremes.
True crime, man. It's a phenomenon.
These Dateline shows that we watch is always like, it's just the culmination of facts that make it easy. You don't have the body, you don't have the weapon, but you have enough facts to give a doubt. And I imagine that works really well for plaintiffs, is just enough facts to show that you're sloppy enough if you're suing that person.
Yeah, I mean, this is why you get advice from people who say, don't say safety is your number one priority. Because if you say safety is your number one priority, all we're going to do is find all the instances where you weren't safe and then say, okay, here's why you ought to be liable. So it's, to your point, it's about following a process that you have that's documented, not deviating from that process when you're trying to find capacity. That is when the lawyers can get their claws into you, because if you have a process and you say you have a process and you don't follow the process, now we're not saying, oh, it's a bad day for this truck driver. Now we're saying it's a pattern. It's a practice of your company to kind of circumvent your own internal documentation. And once you can show that you're not careful on those issues, we can continue to go forward. Unlike the true crime world, so true crime, murder, all this criminal stuff, that is all around proof beyond a reasonable doubt. Not proof beyond any doubt, but proof beyond a reasonable doubt. Think 99% think that's what happened. That's a kind of good analogy. In civil litigation, it's nothing near that. Civil litigation is a preponderance of the evidence. Think flip of a coin plus one. And so the burden of proof in these cases far lower than most Americans understand when it comes to criminal stuff that you see on television. And there's not a lot of great shows about civil litigation, but I'm sure there's something out there somewhere. But that's what really gets people surprised. It doesn't mean that you are for sure guilty of this. It means that you might more likely than not are. And that's enough to get you on the hook for joint and several responsibility for something that happens.
Matt, there are some good shows. You had Suits. I never watched Suits, but I'm well aware of one of the actresses who's now sort of like the UK's enemy number one. And then you had Boston Legal, one of the greatest shows on television.
Yeah.
Unfortunately, rest in peace, Boston Legal. I love that show. That was a fantastic show.
Yeah.
You do have some legal. There are some ones, but they're typically very soapy drama series that don't go into. They're not hard hitting like Dateline, right?
Well, the problem, I can't watch the legal drama.
American Greed's really a criminal thing, right?
It is. So when you're like, as a lawyer, like you see the stuff on television or on Netflix or whatever, it's different than being a lawyer. Like when you're actually a lawyer, you're just sitting in a cubicle or an office looking at documents and highlighting things and then maybe sending emails all day long for 12 or 15 hours a day. It's nowhere near as exciting as you see like trial attorneys going and arguing before judges. Most litigators, if they're really experienced litigators, might litigate one case a year just because most cases settle. So maybe I need to start watching more of the legal stuff. I don't watch a lot of it, Craig. I just don't. I watch a lot of medical and true crime, though.
That's interesting. Do you ever see Landman?
No, you've said great things about it.
You got to watch Landman, but I think the worst scene in television's history is this scene because it's just so fake. Anyone who's ever been in a legal thing, of the young hotshot lawyer in there, and she's like shaking him down, the opposing counsel. It's just so like anyone who's ever been in the legal system, it just doesn't work that way. And I just think
There's no surprises in litigation. Like, you know all the evidence well before you get involved.
Yeah, and you're not gonna. I mean, the whole shakedown thing, and they're like, oh, like it's so fake, and it's unfortunate. Also, there's a weird airplane. By the way, I love Landing Man. It's a great show. There's a weird airplane scene. As someone who knows a lot about airplanes or knows enough about airplanes as a pilot, it just like, someone actually goes, is that actually how it works? Like, no, that isn't how it works, but that's fine. Coming right back, Matt, we got a lot to talk about. We need to unpack this Home Depot show, or this Home Depot lawsuit. You have dug into it. It's an interesting one in the light of Montgomery, where Home Depot was a part of a lawsuit, was sued in the event of an accident, and it rings a lot of questions about negligent hiring and whether that can be enforced against a shipper. We're going to find out what the Texas Supreme Court said about it right after these messages.
Race car drivers like NASCAR champion Jesse Love are a lot like commercial drivers, pros. But even the best in the world still watch the tape to see what they missed and get better next time. So we created the Samsara Driving Coach.
Great race, Jesse, but you were following too closely and you were speeding.
Okay, you got me on that one.
Samsara uses insights from millions of professional drivers to coach drivers in real time.
Because even champions need a coach.
Give me the keys.
What's the masterclass all about? Well, here's what I'm going to tell you. If you're a driver, you're an owner-operator, you're a fleet owner, whether you're in compliance services, dispatcher, no matter what it is, masterclass is for you. Every 2 weeks, you're going to sit down with me, and we're going to go over certain business topics that are related specifically to your small trucking company operations. We're going to help you with everything from compliance to how to negotiate better on the spot board, how to find direct freight, and everything in between. This is the reason why you don't want to miss out on Masterclass. It's about an hour to an hour and a half, and then on top of that, you'll have the library to you so that way you can always research and reflect back onto it. Don't miss out this opportunity. This is built specifically for you. I'm excited, and I hope to see you in class.
Imagine a world where your freight moves as fast as a digital pulse. What if your visibility didn't just tell you where a truck was, but exactly where it needed to be 48 hours from now? Think of a logistics network that corrects its own mistakes before they cost you a single dime. What if your supply chain could think for itself? Imagine AI agents negotiating rates in milliseconds, predictive models that solve labor shortages before they even happen. This isn't science fiction, it's the agenda. On July 15th at the historic Old Post Office in Chicago, FreightWaves presents the Supply Chain AI Symposium. We are defining in real time how AI is embedded into every mile, every warehouse, and every handshake. Because in 2026, the future isn't just coming, it's already negotiating. The FreightWaves Supply Chain AI Symposium. Secure your spot now.
Matt, I love our intro music, by the way. It just has this ominous
amazing.
feeling of like doom and gloom. It's sort of almost like Succession. You ever seen Succession?
I love Succession. That is a phenomenal program, and it does inspire a very nice kind of discordant chaos that we find ourselves in with supply chain. So absolutely, man.
Especially when the attorneys get involved. Speaking of attorneys, I gotta talk about this Home Depot lawsuit. You wrote an article about it. Just for our audience that may not be familiar with it, this is a lawsuit that involved an accident that happened. Home Depot was brought into court, the state of Texas, and the Texas Supreme Court said something about it. Matt, what exactly is the background on this?
Yeah, like so many of these catastrophic accidents, it starts off with a motor carrier that has a collision with someone else. And in this case, it was a motorcyclist. And the terrible accident takes place. They sue the motor carrier. You always sue the motor carrier. You sue the driver. You always sue the driver. The driver is responsible just as much as the motor carrier is. And the motor carrier, it's an agent of the motor carrier. So that's, hold them jointly and severally liable. But then there's a shipper, and the shipper had selected this motor carrier. And the question became before the court, okay, well, shipper, you made a selection of a motor carrier, just like a broker might have done. You maybe picked the wrong motor carrier. Maybe you should have some culpability. And the Texas Supreme Court ended up saying in this case, the passive shipper does not have the responsibility that the motor carrier does. We're not going to hold the shipper, like you might hold a broker, liable for negligent selection. Now, it's important to note here, Craig, that the motor carrier that was selected by Home Depot for this move was Werner Enterprises. And so if you can't select Werner Enterprises and avoid a negligent selection claim, we have bigger problems. And so what this case comes out at, maybe a couple of days or day after the Montgomery case, is it shows the same tension that we have in this industry. The plaintiffs argued, well, Werner has a lot of inspections, a lot of out-of-service things, a lot of accidents, a lot of things that make them appear like they might be unsafe. And so you should have had some responsibility. And the Texas Supreme Court very clearly says a passive shipper who is not in control of the asset, not in control of the driver, not maintaining the equipment is not going to be held liable. Now, this is how Texas finds this case. This is going to be something we're going to see across all 50 states in the years to come, because each one of these are going to be litigated to say what is the standard of care that someone should use when they select a motor carrier. Now, again, Home Depot selecting Werner Enterprises, I don't think you're going to find any broker or shipper who's going to be held responsible for selecting a mega carrier to move full truckloads. That would be absurd. But it goes this tension between how much you control your service provider and how much vetting you need to do on the front end. And that's what this case kind of boils down to. Again, the Texas Supreme Court comes out and says, no, we're not going to hold Home Depot liable for selecting Werner when Werner is a big motor carrier that has got good standing with the FMCSA.
Well, Werner is one company, but you have others that are big. I mean, Western Express has one of the highest accident ratios of all motor carriers that are out there. Could they have argued that if it was a Western Express or a Super Ego claims, they do not identify as a carrier until they do.
That's right.
So, I mean, it's sort of
They're a leasing company. They're a leasing
kind of
company.
like which bathroom do they use? We don't know. It depends on whatever advantage they get. But the reality is, like, if the plaintiff's attorneys were able to demonstrate that Werner was not a safe carrier, if it was someone else, would that have outcome been different?
Possibly. Now, again, they were not making the argument necessarily about the selection being negligent. They argued that initially, but they also tried to argue a theory of respondeat superior. So essentially, you're an agent of the shipper. So you, the motor carrier, are actually working as if you were this. And Texas law is very clear. When you hire an independent contractor to perform a service, your job is not to make sure that they're doing everything proper. Like, your job is to pay the subcontractor to do the work that they're qualified to do. But your point is really well taken. What we're going to have to wrestle with is nationally, the out-of-service rate for commercial vehicles is 22%. I don't like to use crash data as an example of like when someone's safe or unsafe. It's interesting, but crash data on the FMCSA has nothing to do with the finding of liability. So you could have a crash and you could be in the crash and reporting a crash, but someone else hit you. It still looks the same in the government database. The things that you can control are out-of-service things for your drivers and out-of-service things for your equipment. And so if we see a bunch of motor carriers that are above the national out-of-service rate, which again is abysmally high already, maybe that becomes a winning argument. And I think for many plaintiff attorneys, as they start to understand how this industry works and how we look at safety as an ongoing concern, they're going to realize, 94% of motor carriers have no safety rating, and the out-of-service rate is already awful. So if you're even a little bit above that, maybe you ought to be someone who's taken as being hiring someone unsafe. Now, the FMCSA has their work cut out for them. Like, to tell you what motor carriers are safe and unsafe is that's their prerogative. That's their mandate. They just don't have the resources to do that at the scale that we need. And so there's this ambiguity, and the ambiguity is not going to go anywhere. It's going to stay here, and it's only going to be decided through litigation or perhaps an act of Congress. And I don't see Congress getting involved anytime soon with brokers' selection process. That's why my hope is FMCSA gets a lot more resources to go after carriers that aren't safe and do more audits, because that's the only way we can fully understand if someone's a safe motor carrier or an unsafe motor carrier.
Yeah, I mean, look, the FMCSA on their own website says that this is not to rely upon, I mean, even the scores is not to make a safety decision. They have that disclosure there on their website. Matt, so let's take this a little bit further. So we have the Supreme Court decision. It didn't change. It didn't say that brokers are liable or could be held liable. It said that there is no federal preemption to prevent them from being liable. They can't use the F4A in the idea of negligent hiring. That is still something that they're liable to. In fact, in the decision itself, Justice Kavanaugh actually said, look, if the broker is hiring someone safe, they have the incentives to do, then they shouldn't be sued or shouldn't be have to pay out in terms of plaintiffs. But it's going to take a lot of litigation. We're going to see at least 50 different lawsuits, if not hundreds, if not thousands of more, as every single jurisdiction we start to see these lawsuits pop up. But let's talk about Texas specifically. So we have this lawsuit. Do you think that this settles the case on whether shippers are going to be held or could be held liable in the state of Texas?
I think what's going to happen is you're going to have every shipper that selects a motor carrier still get sued. And those shippers will then use motions to dismiss to try to get rid of these claims. And most of the time, they're probably going to be successful. Where we're going to start seeing ambiguity, I think, is when we start taking into account more of the data that can be captured. So the way that SCOTUS kind of phrased, and especially Kavanaugh looked at his concurring opinion, and a concurring opinion, just for everyone who's listening and watching, a concurring opinion is not the opinion. It really is something that's illustrative for other cases, but realistically, it is the justice saying, I agree with the outcome, I agree with the majority, but I have a couple of things I'd like to quibble with or clarify or whatever. So it is not binding law. The concurrence is not binding law on anybody. It's just more of a, again, illustrative or secondary kind of relative to the broader majority opinion. And to say that we don't expect a lot of brokers to be held liable, or don't expect to see a lot of litigation, that's wishful thinking. It's very similar to opening a floodgate and looking at the water and saying, okay, I'm going to let you out, but don't go too fast. Go slow. I want to make sure this is controlled. The water doesn't care what you want. If the gate is open, it is flowing. And so the litigation is absolutely going to continue to happen. For Texas, it is really encouraging. So the Texas Supreme Court had the Werner Enterprises decision that overturned their case. It was awfully decided initially at the trial court and at the appellate court, finding Werner not liable when someone else crossed the center line and collided with them. That's a big win from the Texas Supreme Court. This is another big win for the Texas Supreme Court and for trucking companies more generally and brokers. We don't really want our customers to be held liable for our own mistakes. And that is an important piece that I think the court recognizes in this Home Depot case. But to think that this settles the issue, probably not true. These are going to be fact-intensive questions of what level of vetting did you use, what did you know, when did you know it, and that's what's going to be discoverable over time. So you're going to build a defensible position, but that defensible position may change as technology or data becomes available, which is why, back to our loves analogy, you want to get preventative maintenance of your contracts and of your processes at a reasonable cadence, because things change quickly. So this is a big win for Home Depot, big win for brokers generally and shippers generally, but it is just a taste of things to come. And who knows how much money Home Depot had to spend to litigate this case all the way up to the Texas Supreme Court, likely millions of dollars.
I bet Home Depot was excited that it was Warner, because at least the Supreme Court had some familiarity with the Warner as a company in that really famous lawsuit, an unfortunate lawsuit for Warner, because this was a situation where the truck was on the side of the highway. And what was the number? I mean, it was a big claim. What was the actual jury award? It was in hundreds of millions of dollars, if I'm not mistaken.
For the first Werner case, you mean?
Yeah, yeah.
So that case was fascinating. So the original case, and let's kind of go through the highlights real quickly. Werner is operating its truck below the posted speed limit. They never lost control. The truck and trailer were well maintained, and it was snowing. So the driver, again, was going underneath the posted speed limit. It's like a winter advisory in Texas. The driver in the opposite lane was going too fast for conditions. And we know this because they lost control, spun out, and crossed a 42-foot grassy median and collided with the truck operated by Werner. The driver for Werner probably had 2 to 3 seconds to react once that other vehicle lost control. It went to trial, and at trial, it was found the liability for the truck driver, the driver for Werner, was 14%. And the driver for the pickup truck that lost control and crashed across the median and smashed the Werner truck, they were liable 16%. So that's 30% of liability with those two parties. They found Werner was responsible for 70% of the liability. And the argument that was made by the jury and others was, well, Werner should have told the driver to go slower. They had better ability to say, hey, here's some training on driving in the winter, and you didn't give them the training. And that verdict was initially about $90 million. And Werner appealed that. And after they went on the appeal and they lost the first appeal, that number ballooned to $130 million because of what we call post-judgment interest. So if you get a judgment, you're still going to collect interest on that judgment until it's paid. So Werner took, a big gamble, and they appealed to the Texas Supreme Court. And that case was decided where eventually Werner had no liability. And it went back to the lower court for instructions to that effect. But that case had the entire transportation industry on pins and needles, because how in the world can anybody anticipate the actions of another driver who crosses the other side of an interstate? That's impossible. It's like you driving home from work and someone crashes into you across the median. You're at fault? That's absurd. So the Texas Supreme Court correctly reversed that earlier decision, but these cases are not slowing down. The verdicts continue to rise, and the litigation itself continues to increase.
And we had the state of Missouri. In the state of Missouri, there was a case with Wabash, truck on the side of the road. Trailer was built 20 years ago. It was a trailer whisperer that you are.
That's right.
The fact that this, truck, the car is apparently, the driver's intoxicated, hits that truck at 55 miles per hour. And the argument is that there's no guard. But that was in Missouri. It's a different state entirely. Again, we're talking about these substantial payouts. But I got to ask, Matt, the idea that the shipper was not negligently hiring or couldn't be held liable for some of Werner, the fact that they chose Werner and somehow made a mistake there, certainly protects shippers going forward, or at least provides an argument to protect them. Does this help brokers as well? Can they make the same arguments under that particular decision in the state of Texas?
Yeah, I think it's instructive as you're a broker trying to defend yourself in these sorts of claims. So if you look at the Home Depot case, it has to do with, again, an accident by a trucking company trying to bring in who brought the trucking company into that space, which was the shipper, or sometimes it could be the broker. The same argument's going to be advanced. I couldn't control them. I don't have access to all their stuff. I don't maintain it. I don't own it. That's not my prerogative. They're not an agent of mine. When you go back to the negligent selection piece, it's what did you know, when did you know it, and how does that compare to what your process outlines? So if you're a broker and you're hiring only mega carriers that are publicly traded, I don't think you're ever going to be hit with negligent selection and lose. You might still get sued. You might still fight those cases, but you're probably not going to be found to be negligent when you select a mega carrier. Now, you don't do that because the mega carrier is going to be more expensive probably than working directly with a small owner operator. So this is the challenge that brokers run into. Can you go tender freight to the big motor carriers if they want it? Maybe. But if you're trying to run your business, you are aggregating small capacity. And what you know about small capacity is finite. You only know what's reported by the FMCSA, and they don't get to touch a motor carrier probably in the first 12 to 18 months of that company forming. And every single month, 6,000 new motor carriers kind of enter the industry, while another 6,000 or so leave the industry. So you're in this really difficult position where you're expected to know more about your partner you're working with than the federal government that regulates them. And that's an untenable position. That is why, with the Montgomery case, the U.S. Chamber of Commerce, the FMCSA, the Department of Transportation, all of them did not want the broker to have the liability for negligent selection. That was unanimously found to be wrong. I mean, that is unanimous. There is absolute ability to go after a broker for selecting a motor carrier. But it goes back to the same question. What is a safe motor carrier? And you don't know that until after an accident takes place. And what is a reasonable vetting process? Nobody knows that. No one can tell you what that answer is. The only way we're going to know for sure is as litigation continues to build up across this country. And that takes time. So for brokers out there who are like, am I doomed? You're not doomed, but you better have liability insurance because you have no idea what Ohio will say about your vetting process versus what California will say about your vetting process. And the whole purpose of the federal interstate system that we have is consistency across all markets. That is the one thing we absolutely do not have when it comes to negligent selection of motor carriers. So we're in this really difficult position of trying to give advice and give some options for brokers to use when the reality is none of us know. And we're not going to know until well in advance as we have a lot more litigation making it through the courts. The Home Depot case, though, Craig, is very encouraging. It shows us that if you work with a motor carrier, you're not controlling them. They're not your agent. They're just out there doing a thing for you, and they're a subcontractor for your business. You have a very strong defense. And most states have a strong defense. Federal preemption was a way to say, I'm not even going to get into my selection process. Now we're going to litigate the selection process. And there's a lot of great tools out there to help people do that.
Now, to be clear, this is only applies to the state of Texas. So I imagine courts, or at least attorneys that are arguing in front of courts, will refer to this case, even if it doesn't apply in their state, but at least look at it as a guide. Is that right?
Yeah, that's right. So we call that kind of authority persuasive authority. So yeah, in Illinois, we have our own case law. We have a whole bunch of case law. But if there's a case that's right on point, similar facts, similar kind of evidence, ultimately, maybe even similar law, we can say, well, this is persuasive. This is what one court did. Maybe you should look at it the same way. And the court will note that. They may find it persuasive. They may not. They don't have to. So it's not like it's authority that binds them. But I do think that as we see more of these cases make it to the various Supreme Courts across this country, we'll get a pretty good understanding of what is reasonable vetting processes. So even though that case of Texas is not binding on all shippers across the entire United States, it is persuasive, and it'll absolutely be cited when people say, hey, in this case with similar facts, they weren't found to be liable, so why should I be liable? So I think that'll be encouraging as time goes on. But again, yeah, you're right. It's not binding on any court outside of the state of Texas.
Well, coming up, stay tuned. We've got some conversation around Modus. Caution for those folks that are trying to access Modus, because it has not been fun last couple of weeks. And I want to talk about this hours of service change that was made specifically for fertilizer truckers. And we'll get back to that right after these messages.
Race car drivers like NASCAR champion Jesse Love are a lot like commercial drivers, pros. But even the best in the world still watch the tape to see what they missed and get better next time. So we created the Samsara driving coach.
Great race, Jesse, but you were following too closely and you were speeding.
Okay, you got me on that one.
Samsara uses insights from millions of professional drivers to coach drivers in real time.
Because even champions need a coach.
Give me the keys.
map is changing. As global uncertainties rise, the future of the supply chain is moving closer to home. Welcome to the new coast-to-coast North American network. Driven by massive reshoring trends and next-gen industrial innovation, optimized by AI workflows that build unshakable operational resilience, and locked down by proactive security against evolving freight fraud. Are you ready to navigate the shift? Join the industry's top minds to build the future. The FreightWaves Domestic Supply Chain Summit, streaming live June 17th. Register for free at live.freightwaves.com.
Modus is the biggest technology change in FMCSA's recent history, trying to bring in a bunch of databases. The process has not gone as smooth as one would like. It does bring us back to the memories of healthcare.org that came out right after Obamacare, where the system crashed. That's certainly how the industry is thinking about it. The FMCSA has been really has put out a couple statements, but certainly they have their work cut out for them. Matt, what are your thoughts on Modus right now?
Well, this is a natural progression of how we had to move things forward. As you mentioned, there's a bunch of different databases that were all siloed. And one of the big goals of the FMCSA is to have one place of truth where everything can go. And part of Modus is going to ultimately purge a lot of carriers that are not doing things correctly. Two-factor authentication, a whole bunch of other changes with the new system, but it's change management and nothing ever gets as easy as we hope it is. Deployment is always a challenge. And so I think give it a couple months. That's probably my best advice is it's going to take some time. There are ways you can contact the FMCSA to say, hey, I'm having some trouble here, but this is what we needed. We needed to have this done, and there's a lot of technical debt we have to overcome. And if you want to have the roads safer and you want to have everyone getting stuff that they need on time and undamaged, this is what we have to have. So I'm glad the FMCSA has got this thing going, but there's a lot of work ahead. And I'm sure Administrator Bars and Deputy Administrator Jesse Ellison are having a wonderful time as they navigate this technology.
Yeah, it's like doing a big upgrade of that is so much harder. Taking a big mainframe system, particularly government databases, which are probably 30, 40, 50 years old in some cases, built in COBOL, built in like machine language, and trying to have them talk to modern systems. It's interesting because you always hear, these vibe code founders, these software kids that are doing amazing work, have the benefit of not having technical debt to deal with. And I remember when I started my business, I kept thinking, man, these big companies are just so slow and they suck at shipping new things. I could do this so easily. And then a couple of years after having real customers and real technical debt and real issues, you realize, man, it's easy to ship something when nobody's on it. It's really hard when you have to deal with the existing application layer and a new one. It's totally different. So good luck to the FMCSA. I think the best advice I've heard is stay off it if you don't need to hit it, because it's not really the best place to do it. There's another story this week, I wonder if you caught this, Matt, is the hours of service modification. One of the things that we're seeing from this administration is making modifications to really help out farmers. Earlier this year, we saw that the SBA created small loans for businesses involved in supply chain that had very favorable terms. We're seeing the modifications to the hours of service rules for the truckers that are hauling fertilizer. It also basically changed the way ELDs are treated in this. Any comments on this change?
Yeah, I mean, this is interesting. So fertilizer has become an interesting topic. I don't know if it's directly tied to what's going on in the excursion in Hormuz, because there's a lot of fertilizer that comes out of there. But this waiver of the hours of service, now drivers who are moving non-hazardous, let me me repeat that, non-hazardous fertilizer now have the ability to do 16 hours of driving per day and they have to have a 6-hour rest period. It applies to 35 states. So if you're moving fertilizer, again, non-hazardous, non-hazmat fertilizer, you have 16 hours to drive a day and you have the 6-hour rest period. This goes, I just want to confirm on my notes, August 26th of 2026. So until basically end of summer, there is this waiver for the hours of service. And that is that just shows that we need the fertilizer delivered. And if freight doesn't stop, we have to make sure the drivers aren't stopping as much either. And so that is what this waiver looks to be doing. Again, it does not apply to hazmat. So do not use hazmat. If you have questions about hazmat, talk with your insurer or talk with your lawyer. But for just general non-hazardous fertilizer, you got 16 hours a day until August 26th.
Well, hauling manure has never been more attractive than what we're going to see with this extension or this exception. So I'm sure drivers love that. I got to ask your thoughts, Matt. We've seen the market tighten up. I've talked about this on numerous occasions that the SCOTUS decision is not really a major factor. Maybe it's with C.H. Robinson. In fact, we opened the show with this. Your read on the market conditions, how impactful the SCOTUS Montgomery decision really is at this point?
I mean, SCOTUS does not take cases that are immaterial. They take cases that are incredibly important. And when we first covered this thing, we did it live the day it broke on Freight Expectations. It made a lot of people surprised because obviously we saw all of the business groups that usually have a great track record before the Supreme Court. We saw all of them lose. And now we're kind of wrestling with the aftermath. And I think what we're likely to see is many companies revisiting their carrier selection processes. So if you're in the business, you're going to try to cull more and more of your service providers. That will drive rates up ultimately, but we're still probably too early to tell. With Supreme Court cases, though, the implications are decades in the making. They take a long time to fully get into how we do business. And I think practically the goal for many brokers is to navigate this time, make sure you're following your processes and your procedures. And then as you look to increase your own protection is to have insurance that, again, isn't legally required of you, but it's almost required now in post-Montgomery days. So I think to your question, will the impact be meaningful this year? Probably. I mean, we see CH and others start to cull some of their capacity, but it does not address the fundamental question, which is, are the motor carriers that are authorized to haul freight in the United States safe? And the only agency that has the power to really tell us that does not have the resources to do that. And changing liability from a motor carrier to a broker does not make the motor carrier safer. It does not do that, but it will presumably make it where brokers are more reluctant to work with people that are edge cases. And that's probably a good thing.
Yeah, I mean, look, so much to talk about. A friend of mine on X, he runs a small fleet. His name is Ted. He talked about the fact that he's getting some of the freight. He got cut off by broker. They're going to him directly, some of the shippers. I imagine that's going to be a part of the story. Matt, thank you so much. Great. Start over. Great Freight Expectations, as always. You could watch FreightWaves Today every single day at noon to 2. We bring in the best guest every single day. You can also hear it at Road Dog at 5 to 7 and daily 6 a.m. and 8 a.m. restreamed.
People are clamoring.